In today's update, we're diving into the ongoing court fight, known as Miller versus Bonta, which targets California's statewide prohibition on what the state refers to as assault weapons. There's been a major shift in the legal landscape. A recent, unanimous ruling from the United States Supreme Court, handed down with a vote of 9-0, is now being used to support the argument that this ban on rifles is flat out unconstitutional. Let's break down what's happening. As I mentioned earlier, this video centers on Miller versus Bonta, a prominent lawsuit that directly contests California's sweeping ban on certain semi-automatic rifles that are classified based on cosmetic features rather than functionality. The case just went before a new 3-judge panel in the Ninth Circuit Court of Appeals. It's been bouncing back and forth between the district court and the appellate level for quite a while now, all revolving around one key issue. Does this ban on commonly owned rifles violate the Second Amendment? For a time, the lawsuit was effectively stalled, but things picked back up after the Ninth Circuit weighed in on the Duncan case, which, as you might recall, deals with California's limits on magazine capacity. That decision helped reignite momentum in Miller. But what's really turning heads is a brand new ruling from the Supreme Court, and yes, all 9 justices agreed on it. That case involved the Protection of Lawful Commerce in Arms Act, and it's now being referenced as part of the legal foundation in the Miller challenge. Within that ruling, several justices made it a point to affirm that AR-15 style rifles are widely owned by responsible Americans and used for perfectly lawful activities like self-defense and recreational shooting. In legal terms, that makes these firearms in common use, which, under the Second Amendment, means they're protected and not subject to broad prohibitions like California's. If you're not already familiar with the case, Miller versus Bonta is a constitutional challenge to California's so-called assault weapons law, specifically Penal Code Section 300515. This law bans a wide range of rifles, not based on how dangerous they are, but purely based on external features. For instance, if you've got a semi-automatic centerfire rifle with a detachable magazine, California says you can't legally have a flash hider, an adjustable stock, or a vertical grip. Add any one of those features, and the state classifies it as an assault weapon, making it illegal unless it's specially registered or falls under an exemption. The original ruling in the case came from Judge Roger T. Benitez, known to many of us in the firearms community as Saint Benitez, for his clear and consistent defense of Second Amendment rights. He ruled that California's ban is fundamentally incompatible with both the plain text and the historical context of the Second Amendment. He granted summary judgment in favor of the plaintiffs, the folks challenging the rifle ban. Of course, the state wasn't about to let that decision go unchallenged. California quickly appealed to the Ninth Circuit, where a 3-judge panel took up the matter. And then, everything hit a wall. The case just sat in limbo while the courts dealt with other major gun rights decisions, especially New York State Rifle and Pistol Association versus Bruin. Once the Bruin decision was handed down, which clarified that gun regulations must align with the historical traditions of firearm law in America, the Ninth Circuit sent Miller, along with several similar lawsuits, back to the district court level for another look under the new legal framework. That meant Judge Benitez had to re-examine the case. And no surprise, he came to the same conclusion once again. California's rifle ban cannot stand under the Second Amendment, especially when evaluated through the text and tradition standard, now reaffirmed by Bruin. As expected, California filed another appeal, and the case is once again before a 3-judge panel in the Ninth Circuit. That's where things currently stand, waiting for the next judicial move. But here's the twist. Once again, the Miller case ended up stuck on the sidelines. Why? Because it was queued up behind the Duncan case, the one dealing with so-called high-capacity magazines, which was being considered en banc by the Ninth Circuit. Oral arguments in Duncan had already taken place, but the court sat on it for almost a full year. And since Miller was right behind it in line, that case sat idle just as long. Eventually, the Ninth Circuit did hand down a ruling in Duncan. They sided with the state and upheld California's restriction on standard capacity magazines, saying the law does not infringe on the Second Amendment. That ruling is now being challenged and may soon head to the Supreme Court for review. So, while we wait on the next move in Miller, what's clear is that this case is setting up to be a pivotal moment for gun rights in America. And with a recent 9-0 ruling from the Supreme Court backing the idea that commonly owned rifles are protected under the Constitution, the momentum is definitely shifting. Now that the Ninth Circuit finally issued a ruling in the Duncan case, the Miller lawsuit is back in motion. Earlier this year, back in January, the court finally held oral arguments for Miller. I listened to the full hearing, and let me tell you, the bias from certain judges was on full display. Judge Bress and Judge Nguyen, in particular, repeatedly misrepresented the AR-15 platform, at one point even calling them machine guns, or just referring to them as A-15, which honestly shows a lack of basic familiarity with the firearm. Their language made it painfully obvious that they lacked technical understanding of the rifle or its popularity among responsible American gun owners for home defense, sport shooting, and regular range use. Throughout the hearing, both Judge Bress and Judge Nguyen took aim at the common use standard that was laid down in District of Columbia versus Heller and reaffirmed in Bruin. They described it as circular logic and suggested it was unreliable. Judge Nguyen went so far as to question the data showing that millions of AR-15 pattern rifles and other semi-automatics are in civilian hands across the country. She even floated the idea that, even if such rifles are widespread nationwide, within California's borders, ownership numbers supposedly weren't high enough to meet the common use threshold. Since then, we've all been waiting to see where the Ninth Circuit would land. But just last month, something major happened. The United States Supreme Court released a unanimous 9-0 decision in the Smith & Wesson case. And here's the kicker within that decision. The court made a crystal clear statement, confirming that rifles like the AR-15 are commonly owned and used for lawful purposes by the American public. That directly refutes what was said during the Miller oral arguments by Judges Bress and Nguyen. Not surprisingly, the plaintiffs in the Miller case have now filed a supplemental brief, pointing to that Smith & Wesson ruling as further proof. They argue that this Supreme Court decision reinforces what gun owners have known all along, that the AR-15, the AK-47, and even .50 caliber precision rifles are all commonly possessed by law-abiding citizens across the country. In that case, the court rejected Mexico's lawsuit against firearm manufacturers, which had claimed that so-called military-style rifles were fueling violence through their marketing and design. But the Supreme Court's answer was clear. These rifles are perfectly legal, widely sold, and regularly purchased by everyday Americans. In their filing, the plaintiffs emphasized that the AR-15 is, hands down, the most widely owned rifle in the United States. And since the Supreme Court's commentary on that fact was part of its legal reasoning, not just casual commentary, it carries real legal authority. The court has consistently stated that firearms commonly in use by the public are protected under the Second Amendment and cannot be outlawed through sweeping bans. So now, the position taken by those Ninth Circuit judges that rifles like the AR-15 aren't commonly used has been thoroughly undercut. Since the hearing took place, the highest court in the country has doubled down, reaffirming that these rifles are not only in lawful use, but also shielded from prohibition by the Constitution. At this point, if this panel of judges wants to uphold California's rifle ban, they'll have to take one of two routes. Either completely ignore what the United States Supreme Court just clarified, or twist it, claiming the statements from Smith & Wesson don't count because that case focused on the protection of lawful commerce in Arms Act. They might try to say the comments about the AR-15 were just incidental, what legal professionals call dicta. But we've seen this playbook before. The Ninth Circuit has a reputation for brushing aside clear Supreme Court rulings when it comes to the Second Amendment, just like they did after Heller and Bruin. Up to this point, the highest court in the nation has yet to step in and set the record straight. The Supreme Court has passed on several chances to overturn lower court decisions that upheld bans on so-called high-capacity magazines or restrictions on popular semi-automatic rifles. That silence has only encouraged judges, especially those in the Ninth Circuit, to keep pushing legal interpretations that run contrary to the Constitution and fly in the face of the court's own rulings. Now, there's a possible twist coming in Miller versus Bonta. If the panel reviewing the case wants to avoid directly defying what the Supreme Court just clarified in the Smith and Wesson decision, they've got another card they can play: delay. They might claim, we're going to hold off issuing a ruling here and wait to see what the Supreme Court does with Duncan. That's the case targeting California's restrictions on magazine capacity. The Ninth Circuit already sided with the state in that one, but the California Rifle and Pistol Association is preparing to file for Supreme Court review a formal writ of certiorari on July 18th. If that petition is submitted on schedule, it wouldn't take much for the Ninth Circuit to say, well, Miller is closely connected to Duncan, so we'll wait until the High Court in Washington weighs in before we decide anything. It's a convenient way to hit the pause button, yet again, without having to put out an opinion that might directly conflict with recent Supreme Court precedent. Looking at the national scene, it's very possible that one of the other major lawsuits gets there first. The challenge to the Illinois rifle ban under the Protect Illinois Communities Act is still working its way through the Seventh Circuit. There's also the legal battle over New York's so-called assault weapon restrictions in the Third Circuit. Either one of those cases could reach the Supreme Court before Miller does, especially since the Ninth Circuit has dragged its feet on Miller for years now. At this rate, we might have to wait for the court to take up Duncan before the justices finally clean up the legal mess these lower courts keep creating. Now, to be fair, there's some positive momentum on our side, but the hard truth is that the Ninth Circuit can continue slow-walking this case as long as it wants. That's the current reality we're dealing with. And as soon as something breaks, whether it's a ruling, a petition, or a shift in one of these key lawsuits, I'll be here to break it down for you. Thanks for sticking with me. If you found this helpful, give it a thumbs up, drop your thoughts in the comments below, and make sure to subscribe if you haven't already. And remember, this nation was built by patriots who stood their ground. It'll be defended and preserved the same way.